I have learned that the fastest way to discover who truly believes they own something is to hand them the bill for damaging it. The morning the homeowners association laughed at my $30,000 invoice, they believed they had already won. They saw one man standing beside a quiet lake with a stack of paperwork in his hand. What they did not see was 40 years of forgotten property records waiting patiently beneath the surface of their confidence. My name is Ethan Brooks. I am a 43-year-old civil engineer, and I have spent most of my career solving problems that other people created because they assumed instead of measuring. That habit followed me home the day I bought a piece of lakeside property in a quiet Colorado neighborhood where everyone believed the homeowners association controlled every inch of water, shoreline, and walking trail. They were about to discover how expensive assumptions could become. The morning air carried the cool scent of fresh pine mixed with damp earth rising from the lake after a chilly night. Small ripples rolled across the glass like water while geese drifted near the opposite shoreline without any concern for the argument unfolding on land. I stood beside my pickup truck holding a blue document folder in one hand and a steaming cup of black coffee in the other as the sound of diesel engines echoed through the neighborhood. Two large excavation machines slowly rolled toward the shoreline, followed by a landscaping truck with the Homeowners Association logo displayed proudly across both doors. Workers climbed out wearing bright safety vests before immediately unloading equipment. They never walked toward my front door. They never knocked. They never asked permission. Instead, they began removing a section of natural stone retaining wall that bordered the edge of my property, pushing heavy equipment across freshly planted native grass that I had spent months restoring. I watched the steel tracks press deep marks into the damp soil, while broken stones scattered across the shoreline with sharp cracking sounds that echoed over the water. Every movement was deliberate. Every dollar of damage quietly added itself together inside my head. A few neighbors wandered outside carrying coffee mugs, curious about the unexpected construction activity. Some smiled, believing the Homeowners Association was improving the community lake before the busy summer season. Nobody realized the machines were sitting entirely on privately owned land. Then Linda Harper arrived. She stepped out of her sport utility vehicle wearing pressed business casual clothes, expensive sunglasses, and the confident smile of someone who had never expected to hear the word no. She greeted several neighbors before walking directly toward me without slowing her pace. "Good morning, Ethan," she said with practiced politeness. "We are finally repairing this shoreline." I looked at the broken retaining wall, then at the fresh tire tracks cutting across my property. "No," I answered calmly. "You are damaging my shoreline." She gave a quiet laugh, removing her sunglasses as if I had told an amusing joke. "The association owns this lake." I took one slow sip of coffee before setting the cup on the tailgate of my truck beside the blue folder. Without raising my voice, I opened the folder and removed a neatly printed invoice addressed to the Homeowners Association. Across the top, in bold black letters, it read, "Property damage invoice. Total amount due, $30,000. I handed the invoice to Linda. She glanced at the total, smiled even wider, and laughed loudly enough for the nearby neighbors to hear. Then she folded the paper once, twice, and tossed it back toward my chest. "We are not paying this," she said confidently. "We own the lake." I caught the invoice before it touched the ground, carefully flattened the corners with both hands, and placed it back inside the blue folder exactly where it had been. Then I looked directly at her and smiled. "I was hoping you would refuse." Linda stood there for another few seconds wearing the same confident smile before turning back toward the contractors and telling them to continue. The sound of heavy equipment returned almost immediately as another section of natural stone shifted into the bucket of the excavator. I did not argue. I did not raise my voice. I simply watched every movement while quietly recording the time, the equipment numbers, and the sequence of events inside a small notebook that had lived in my truck for years. People often assume engineers spend their lives calculating numbers. The truth is that we spend far more time documenting facts because memories change while written records rarely do. Standing beside the lake that morning, I already knew this disagreement had started many years before either Linda or I realized it existed. I had purchased the property almost 7 years earlier after spending months searching for a place where I could eventually slow down without giving up the work I loved. The neighborhood itself was beautiful. Tall pine trees surrounded the shoreline. Mountain air drifted across the water every morning, and families gathered around the lake throughout the summer. The listing described the property as a quiet lakeside parcel with exceptional privacy. Most buyers focused on the view. I focused on the paperwork. Years of designing infrastructure projects had trained me to distrust assumptions hidden inside real estate descriptions. Before closing, I ordered an independent boundary survey, reviewed the county plat maps, examined recorded easements, and spent an afternoon inside the county records office reading documents that few people had opened in decades. That was where I discovered something unusual. Buried beneath subdivision amendments, engineering drawings, and aging maintenance agreements sat the original development records from more than 40 years earlier. Several pages had yellowed with age, and some survey maps carried handwritten notes from engineers long retired. Most people would have considered them little more than historical paperwork. I recognized them as the foundation of every property right surrounding the lake. One recorded document described the shoreline parcel that eventually became my property. Another established maintenance responsibilities. A third referenced permanent access corridors that connected several neighborhood utilities. Piece by piece, the entire picture slowly came together. By the time I finished reviewing every recorded document, I understood something almost nobody else did. The Homeowners Association managed many community amenities, but ownership and management were never the same thing. Somewhere over the decades, those two ideas had quietly merged inside the neighborhood's collective memory until everyone repeated the same belief without ever verifying it. I never mentioned my discovery because there was no reason to create conflict. I simply stored certified copies inside a blue document folder and placed digital backups in multiple secure locations. Life continued peacefully. I maintained my shoreline, replaced the aging retaining wall, planted native grasses to reduce erosion, and greeted neighbors with the same friendliness I would have offered anywhere else. Most of them were good people. They genuinely believed the lake belonged entirely to the association because that was what they had always been told. Linda believed it more strongly than anyone. Every board meeting, newsletter, and community announcement referred to the lake as HOA property without ever citing a recorded deed. That confidence grew stronger each year, while the original county records sat quietly inside filing cabinets waiting for someone willing to read them. As another load of broken stone disappeared into the contractor's truck, I looked across the calm water reflecting the bright Colorado sky and realized the invoice I had just handed Linda was never the real beginning of this story. The real beginning had started 7 years earlier inside a silent county archive, where forgotten documents patiently preserved a truth that nobody else had bothered to find. By the time the contractors loaded the last broken section of retaining wall onto their truck, the shoreline looked nothing like it had only a few hours earlier. Deep tire tracks crossed the damp grass, scattered stones rested along the edge of the water, and several newly planted native shrubs leaned at awkward angles after being brushed aside by heavy equipment. Linda thanked the crew as though another successful community improvement project had just been completed. Several neighbors even applauded politely before returning to their morning routines, believing they had witnessed responsible maintenance performed by the Homeowners Association. I simply closed the blue document folder, finished my now lukewarm coffee, and drove directly to my office instead of cleaning the shoreline. There would be plenty of time for repairs later. Right now, every fresh tire mark and every displaced stone had become evidence. My office occupied the second floor of a modest engineering building about 15 miles from the neighborhood. The familiar scent of printer toner, rolled construction drawings, and fresh coffee greeted me as I unlocked the door. I scanned every photograph I had taken that morning, organized them by time, and added copies of the contractor vehicle numbers, equipment identification, and property damage estimates into a growing digital file. Once everything had been saved in multiple locations, I made 3 phone calls. The first was to the licensed surveyor who had completed my boundary survey years earlier. The second was to the title company that had handled my property purchase. The third was to a real estate attorney I had worked with on infrastructure easement projects long before buying my home. None of the conversations lasted more than 15 minutes because none of them began with emotional complaints. They began with recorded document numbers. Before lunchtime, the surveyor agreed to verify every monument along the shoreline. The title company confirmed they still maintained archived closing records dating back to my purchase. My attorney asked me to send copies of every county document I had referenced during our conversation before recommending the next legal step. Everything moved quietly, professionally, and exactly the way I expected experienced people to handle questions involving property rights. Meanwhile, the Homeowners Association moved in the opposite direction. That afternoon, an electronic notice appeared in my email stating that I had interfered with authorized community improvements by challenging the board's maintenance authority. 2 additional violation notices arrived before sunset, warning that failure to cooperate with future lake maintenance could result in fines and possible legal action. I read each notice once before placing printed copies into the same blue folder where my original county records had rested for years. Every letter carried another assumption presented as fact, yet none included a recorded deed, survey, or ownership reference supporting the claims. Later that evening, I walked slowly along the shoreline as the setting sun reflected orange light across the calm lake. Several neighbors waved politely, while children rode bicycles along the nearby walking path. One man stopped to ask whether everything had been resolved after the morning construction. I smiled and told him the paperwork was only beginning. He looked surprised because, like nearly everyone else in the neighborhood, he believed the Homeowners Association could never be wrong about something as obvious as the lake. I did not correct him. There was no reason to argue with opinions when certified records would soon speak for themselves. As the breeze carried the scent of pine across the quiet water, I noticed one small brass survey monument still resting exactly where it had been placed years earlier beneath the edge of the grass. The contractors had driven within inches of it without realizing that tiny piece of metal would soon become one of the most important witnesses in the entire case. 3 days later, I met the surveyor just after sunrise beside the same stretch of shoreline where the contractors had worked. The lake looked peaceful again from a distance, but every fresh scar left behind by the machinery remained exactly where I had photographed it. A light breeze carried the familiar scent of pine across the water, while the quiet clicking of survey equipment replaced the rumble of diesel engines that had filled the air only days earlier. My surveyor, Daniel Pierce, had spent more than 25 years establishing legal property boundaries throughout Colorado, and he approached every project with the same calm precision. He unfolded the original certified survey from my purchase, positioned his equipment over the small brass monument hidden beneath the grass, and nodded before taking a single measurement. "It has not moved," he said. That simple sentence mattered more than most people would ever understand. Over the next several hours, we located every recorded monument surrounding my parcel. Each one matched the original survey within accepted engineering tolerances. The boundary had never changed. The land had never shifted. The legal description remained exactly as it had been decades earlier. By mid-morning, Daniel completed a revised field verification confirming that the damaged retaining wall, the disturbed shoreline, and every tire track from the contractors rested entirely within my recorded property boundaries. I thanked him, collected the signed survey documents, and drove directly to the county records office. The building was quiet except for the occasional turning of pages and the soft tapping of keyboards behind the public records counter. I requested certified copies of several documents I had reviewed years before, including the original subdivision plat, the developer's recorded easement agreements, maintenance declarations, and the first conveyance documents transferring individual parcels after the neighborhood was built. One by one, the certified copies arrived with raised seals pressed into each page. As I carefully organized them across the reading table, a pattern became impossible to ignore. The Homeowners Association had been granted authority to maintain certain common amenities, collect assessments, and coordinate neighborhood improvements, but ownership of the shoreline bordering my parcel had never transferred away from the original legal description. Even more significant, the maintenance corridor leading to several critical lake structures crossed my land through a specifically recorded easement. The easement granted limited access for maintenance under defined conditions, but it did not transfer ownership. Management, access, and ownership were 3 completely different legal concepts. Yet somewhere over 4 decades they had been blended together until no one questioned the difference anymore. That afternoon, my attorney reviewed every certified document, comparing each page against the current county records database. He leaned back in his chair after nearly an hour of careful reading and slowly closed the final folder. "The documents are remarkably consistent," he said. "If these records remain uncontested, the association has been operating under assumptions rather than verified ownership." There was no excitement in his voice, only professional observation. That was exactly what I wanted. Strong legal cases rarely depended on dramatic speeches. They depended on facts that remained unchanged no matter who read them. As I left his office carrying the blue folder that now contained fresh certified copies alongside the originals, my phone vibrated with another electronic notice from the Homeowners Association. This one demanded immediate payment of newly assessed fines for refusing to cooperate with community maintenance activities. I smiled quietly before filing the notice into the growing stack of correspondence because every new letter continued telling the same story. The association kept insisting it owned something that every certified county record calmly said it did not. The following Monday, my attorney mailed a formal settlement package to the Homeowners Association instead of filing anything with the court. I wanted to give them every reasonable opportunity to correct the mistake before the situation became more expensive for everyone involved. Inside the envelope were the certified survey, copies of the recorded deeds, the original subdivision plat, photographs documenting the damaged shoreline, the contractor equipment locations, and my $30,000 property damage invoice. The letter itself was direct, respectful, and remarkably simple. It requested payment for the documented damage, recognition of the recorded property boundaries, and future coordination before any maintenance activity entered my land. In return, I was prepared to grant a written maintenance access agreement that would allow the association to continue caring for the lake exactly as residents expected. Nobody would lose access. Community events could continue. The only difference would be that everything would finally match the public records instead of neighborhood assumptions. For several days I heard nothing. Then the response arrived. It was not a settlement. It was another certified letter from the Homeowners Association rejecting every request. According to the board, they maintained complete authority over the lake, the shoreline, and every improvement surrounding it. My invoice was dismissed without discussion. The damage was denied despite the photographs. The survey was described as irrelevant because the association believed decades of customary practice outweighed recorded ownership. Reading those words, I realized they had made the exact decision my attorney expected. They were not evaluating documents anymore. They were defending tradition. There is an important difference between those two ideas, and only one of them carries legal weight. That afternoon, I met my attorney again. We spread every document across the conference table in chronological order, beginning with the original development records and ending with the latest rejection letter. He reviewed each page one final time before placing the Homeowners Association response on top of the stack. "They have now acknowledged receiving the evidence," he said calmly. "That matters." I nodded because I understood exactly what he meant. From that point forward, nobody could claim they had never been informed. Every future decision would be made with full knowledge of the certified records. We finalized the legal filings that had been sitting in draft form since the day Linda laughed at my invoice. They requested compensation for the documented property damage, recognition of the recorded property boundaries, and enforcement of the legal rights attached to my parcel. Most importantly, we prepared the paperwork necessary to suspend unauthorized access across my property until a lawful agreement existed. It was not revenge. It was the ordinary legal remedy available to every property owner whose land had been used without permission. As I left the law office, the late afternoon sun reflected across the windows of nearby buildings, reminding me of the same light dancing across the lake outside my home. My phone buzzed once more with another electronic notice from the Homeowners Association announcing additional fines for refusing to cooperate with future maintenance operations. I quietly saved the message beside the others and placed my phone back into my pocket. Every notice they sent strengthened the timeline. Every rejection confirmed they had chosen confidence over verification. They believed I would eventually give up because one homeowner could not possibly challenge an entire association. They never realized I had stopped trying to convince them weeks earlier. From that moment on, I was simply allowing the law to follow the path their own decisions had created. The legal filings moved through the system with far less drama than most people imagine. There were no raised voices, no dramatic confrontations, and no surprise visits from television cameras. Instead, there were certified mail receipts, court schedules, recorded exhibits, and carefully written responses supported by documents that had existed for decades. A few weeks after the Homeowners Association rejected every opportunity to resolve the matter voluntarily, the first official orders began taking effect. My attorney called early one morning while I was replacing several damaged stones along the shoreline. His voice remained as calm as it had been from the beginning. "The court has recognized your recorded property interests while the case proceeds," he said. "Unauthorized access across your parcel can no longer continue." I thanked him, ended the call, and stood quietly beside the water for several moments as the morning sun reflected across the lake. Nothing about the view had changed, yet everything about the legal landscape had. That afternoon, professionally printed notices were installed only where the recorded property boundaries required them. They were not aggressive. They simply stated that access beyond a certain point required the permission of the property owner unless otherwise authorized by recorded easement or written agreement. Temporary barriers marked the maintenance corridor until future access could be coordinated lawfully. Every sign had been reviewed by my attorney before it was placed. Every location matched the certified survey completed only weeks earlier. By the following weekend, the effects spread across the neighborhood. The landscaping company scheduled to perform seasonal shoreline maintenance arrived with trucks and equipment before stopping at the newly posted boundary markers. Their supervisor stepped out, reviewed the documentation I provided, made several phone calls, and then instructed the entire crew to leave without performing any work. They were professionals. Once they realized a legal dispute involving recorded ownership existed, they understandably refused to enter private property without proper authorization. The quiet departure of those trucks attracted far more attention than any loud argument ever could have. Neighbors gathering for their morning walks stopped beside the lake, looking from the empty maintenance vehicles to the temporary notices with visible confusion. Questions began spreading through the community much faster than rumors usually traveled. Why had the work stopped? Why were contractors refusing to continue? Why had the shoreline suddenly become subject to legal restrictions? Linda attempted to reassure everyone that the association was handling the situation, but confidence sounded noticeably different once documented court filings became part of the conversation. Even board members who had previously repeated the same assumptions now started requesting copies of surveys, deeds, and county records for themselves. My mailbox filled with polite letters from residents asking whether community access to the lake would disappear permanently. I answered every one of them with the same response. I had never wanted to close anything. I had repeatedly offered a lawful access agreement that protected both the neighborhood and my property rights. The only thing preventing that agreement was the board's refusal to acknowledge the public records. Late that evening, I walked slowly along the shoreline carrying the same blue document folder that had followed me since the first day of the dispute. The temporary notices reflected softly in the still water, while the breeze carried the familiar scent of pine through the cooling air. For the first time since the contractors crossed my land, the lake was completely quiet. There were no machines, no instructions shouted across the shoreline, and no assumptions being treated as facts. There was only silence, recorded property lines, and the unmistakable realization that the Homeowners Association had finally reached a point where confidence alone could no longer move them across my land. Within another week, the atmosphere around the neighborhood changed in ways that no board meeting agenda could control. The lake was still there, the walking trails remained open where they crossed community property, and the mountain breeze still carried the familiar scent of pine across the calm water every evening. Yet conversations had become noticeably quieter. Instead of discussing landscaping projects or weekend fishing, neighbors gathered in small groups asking a single question that nobody on the board seemed eager to answer. Who actually owned what? I could hear those conversations while replacing the final section of native grasses damaged by the excavation equipment. People who had barely spoken to me during the previous month now stopped at the edge of my property, not to argue, but to ask whether the certified documents were really as clear as everyone was saying. I answered every question the same way. I never offered opinions. I simply showed anyone who asked the recorded survey, the certified county plats, and the public deeds that anyone could request for themselves. I encouraged them to verify every page independently because facts become stronger when they survive careful examination. By the end of the week, several homeowners had visited the county records office on their own. They returned with the same surprised expressions I had worn 7 years earlier when I first uncovered the original development records. During the next Homeowners Association board meeting, attendance reached levels that longtime residents later admitted they had never seen before. Folding chairs filled quickly, neighbors stood along the walls, and every seat at the front of the room faced Linda and the rest of the board. The atmosphere remained respectful, but it carried a seriousness completely different from previous meetings. Homeowners were no longer interested in opinions or reassurances. They wanted documentation. One resident politely asked where the recorded deed transferring ownership of the shoreline to the Homeowners Association could be found. Another requested copies of the legal authority supporting the recent fines that had been issued against me. A retired accountant quietly asked whether the association had ever obtained an independent title review before spending assessment money on improvements located outside recorded common property. Each question was calm, direct, and impossible to dismiss with confidence alone. Linda attempted to explain that the neighborhood had always operated under the same understanding since the subdivision was built, but even she could hear the weakness in that answer once certified public records entered the discussion. Tradition explained habits. It did not replace deeds. One board member who had remained mostly silent throughout the dispute finally requested a short recess so the directors could privately review the documents residents had brought to the meeting. Nearly 30 minutes later, they returned looking far less certain than when the evening had begun. No decisions were announced, but for the first time the board acknowledged that additional legal review would be necessary before taking any further action regarding the shoreline. I did not attend the meeting because my attorney had advised me to avoid unnecessary involvement while the legal process continued. Instead, I spent the evening sitting on my back patio overlooking the quiet lake with a cup of black coffee resting beside the same blue document folder that had become an unexpected companion throughout the entire dispute. As the last sunlight faded behind the mountains, I realized the strongest shift had not occurred inside a courtroom or through a legal filing. It had happened when ordinary homeowners stopped accepting assumptions and started asking for proof. Less than 2 weeks after the crowded board meeting, my attorney called with the update I had expected since the Homeowners Association rejected the settlement package. Their legal counsel had finally completed an independent review of the county records, the certified surveys, and the original subdivision documents. This time the conversation sounded completely different. Nobody questioned the authenticity of the deeds. Nobody challenged the survey monuments. Nobody claimed that decades of neighborhood tradition outweighed recorded ownership anymore. Instead, they asked whether I would be willing to meet before the next scheduled court hearing to discuss a permanent resolution. I agreed immediately because I had never wanted a prolonged legal battle. My goal had always been to protect my property while preserving the neighborhood that had become my home. The meeting took place inside a quiet conference room at a local mediation office. Sunlight filtered through tall windows onto a polished wooden table covered with organized folders, certified maps, engineering drawings, and copies of the same public records that had quietly waited inside county archives for more than 40 years. Linda entered with the association's attorney and several board members. She looked noticeably different from the confident woman who had laughed at my invoice beside the lake. Her confidence had been replaced by careful attention to every document placed in front of her. Nobody raised their voice. Nobody accused anyone of bad intentions. The discussion focused entirely on solutions. My attorney began by reviewing the documented property damage and the $30,000 invoice that had started the dispute. Their attorney acknowledged the certified surveys and confirmed that the independent title review matched every material conclusion contained in my records. That single statement changed the entire tone of the meeting. Once everyone accepted the same set of facts, solving the problem became remarkably straightforward. I explained that I had no interest in preventing families from enjoying the lake, canceling community events, or creating unnecessary obstacles for future maintenance. I simply wanted the legal boundaries respected and future access handled through properly recorded agreements instead of assumptions. The proposal we had offered weeks earlier remained on the table with only minor revisions. The homeowners association would compensate me for the documented property damage, formally recognize the recorded ownership boundaries, and execute a permanent maintenance and access agreement defining exactly when crews could enter my land, under what conditions, and with advance notice. In return, the temporary restrictions would end once the agreement became effective, allowing routine maintenance to continue without future disputes. The board members reviewed every page carefully before asking several practical questions about scheduling, insurance, and maintenance responsibilities. Those conversations sounded refreshingly ordinary because they were based on facts instead of misunderstandings. Even Linda eventually nodded while reading the certified survey one final time. Quietly, without excuses, she admitted that the board had relied too heavily on inherited assumptions and had never independently verified the original property records. Hearing those words brought no sense of triumph. They brought relief. Communities function best when people are willing to correct honest mistakes instead of defending them forever. As the meeting concluded, draft agreements were exchanged for final review, and both attorneys agreed to prepare the documents necessary to resolve the pending legal issues. Walking outside into the crisp Colorado afternoon, I noticed the familiar scent of pine carried by the breeze, reminding me of every morning I had stood beside the quiet lake believing that patience would eventually accomplish what arguments never could. 3 weeks later, the final agreement was signed, recorded, and filed with the county, ending a dispute that had quietly reshaped an entire neighborhood. The homeowners association paid the $30,000 property damage claim exactly as documented, withdrew every violation notice and fine they had issued against me, and formally acknowledged the recorded property boundaries exactly as they had existed for decades. In return, I signed a permanent maintenance and access agreement that clearly defined when the association could enter the maintenance corridor, how advance notice would be provided, what insurance requirements applied, and how future repairs would be coordinated. Every responsibility was written in plain language. Every boundary matched the certified survey. Every signature rested on verified public records instead of assumptions passed from one board to the next. A few days later, the temporary notices along the shoreline were removed, and the landscaping company returned to complete the seasonal maintenance they had postponed during the legal proceedings. This time, the supervisor greeted me with a handshake before unloading a single piece of equipment. We reviewed the recorded access agreement together, confirmed the work schedule, and walked the shoreline as partners instead of strangers standing on opposite sides of an argument. The familiar sound of landscaping equipment once again echoed across the lake, but it felt entirely different because every person present understood exactly where they could work and why. Throughout the following weeks, neighbors slowly returned to their normal routines. Children laughed along the walking paths, fishing lines stretched quietly across the calm water during cool mornings, and evening conversations replaced legal speculation with ordinary neighborhood stories again. Several homeowners stopped by my house simply to thank me for insisting that everything be handled correctly. More than one admitted they had originally believed I was trying to take something away from the community. After reading the public records themselves, they realized I had spent months offering the very solution that ultimately protected everyone's long-term interests. Linda resigned as president before the next election cycle, explaining that the board deserved new leadership after the mistakes that had been made. I wished her well because carrying resentment would have accomplished nothing. People make poor decisions when confidence replaces verification. The important part is recognizing the difference before even greater damage follows. One quiet evening near the end of summer, I stood beside the rebuilt retaining wall with a fresh cup of black coffee resting on the tailgate of my pickup truck. The native grasses had already begun filling the areas damaged by the excavation equipment, and the natural stone reflected the golden light of the setting Colorado sun almost exactly as it had before the dispute began. The same blue document folder sat beside my coffee, although it was noticeably thinner now that most of its contents had become recorded agreements instead of pending evidence. I opened it one final time, looked at the certified survey, the county plats, the signed settlement, and the recorded maintenance agreement before carefully closing the folder and placing it behind the seat of my truck. It belonged there now, not because I expected another fight, but because preparation had always been the quiet foundation beneath every peaceful outcome. Looking across the still lake as the evening breeze carried the familiar scent of pine through the fading light, I realized I had never legally taken the lake away from anyone. I had simply reminded an entire community that ownership is established by facts, trust is preserved by honesty, and lasting peace begins the moment people choose documented truth over comfortable assumptions.